Good morning, delegates. I'm Ruti Rajan, Deputy Editor of the Oath Legal Magazine. Thank you for joining the Oath GC Talk webinar series. This morning, our webinar is in association with the law firm BSA Ahmed bin Hazim and Associates and legal research partner LexisNexis. The topic this morning is on preparing for litigation, a UAE Courts system guide. For those unaccustomed to the UAE civil law system, litigation can be daunting. In this session, partner Haytham Alieh will guide you through the journey of preparing for litigation in the UAE courts, examining some of the key aspects such as the steps to take from pre-litigation through the first judgment, methods of objection or appeal, the differences between local and federal law, how the courts take witness statements, and so on. Our speaker, Haytham, is a partner at the firm. He is an accomplished lawyer and legal counselor with over 24 years experience in the Middle East. As well as being skilled in drafting and reviewing complex commercial documentation, he has extensive experience in litigation across a variety of sectors, including banking, real estate, and retail, in both a contentious and advisory capacity. He is also adept in the enforcement of arbitral awards and foreign judgments within the UAE courts. He will be assisted by Rita Ayoub. Rita is an associate within the litigation department of BSA, where she regularly assists in major arbitration disputes before the various UAE arbitration centers and with commercial disputes before the Dubai and Abu Dhabi courts. Haytham will lead the session for the first half, and this will be followed by the Q&A session. There is an option on the right side of your panel on both the laptop and the phone to type and send in your queries. As it is a session that is scheduled for 1 hour, we request you to send in queries that are relevant to our discussion today. Over to you, Haytham.
Thank you. Good morning, everyone. Thank you for taking the time to attend today's webinar, and I thank our partners LexisNexis on arranging this session. The aim of this session is to walk you through some of the aspects, starting by explaining a little bit about the legal system in the UAE, and then going through with the how we do the disputes and the litigations in front of the court, some of the differences, just to give you, of course, a general guide on this. Of course, some of the topics we cannot, go deeply through because some of the topics are very complex and could take hours to explain. So our webinar of today is going to be more of a general guidance on how to do cases in front of the UAE courts. What are some different aspects in that regard? Start with the UAE, as most of you know, consists of 7 emirates. Those emirates, they share among themselves what we know as the federal law of the UAE, that law which covers all of the 7 emirates, and then each emirate has its own authority to establish its own laws. That's why we differentiate when we say a federal law, which applies on all of the UAE, and a local law which applies only on that emirate in particular. For example, the real estate law in Dubai is different than the real estate law in Abu Dhabi. But when we're talking about, for example, criminal law is the same all over because it applies on any act that happens on the soil of the UAE. That being said, having that differentiation between the federal and the local laws, of course, the constitution of the UAE has also allowed the emirates, each emirate, to have its own judicial system. Currently now we have 3 emirates that have the full level of courts. I'm going to be talking about that, which is Abu Dhabi, Dubai, and Ras Al Khaimah, or RAK, as some of you know it. The other emirates, Sharjah, Umm Al Quwain, Fujairah, and Ajman, when they reach a certain level of the dispute in front of their courts, they reach a level where they have to go to the federal courts. Also, we will be talking about that. So based on this, we can see that the judicial system in the UAE, since it's made out of federal and local laws, so also there will be federal and local courts as well. And hence the differentiation between that, as I mentioned earlier, one is If we're talking about a specific topic that's related, for example, of a real estate matter in Dubai, that should be in front of the local court. Whereas the other Emirates, as I mentioned, who do not have the full applying judicial system, like as I mentioned, like Sharjah or Ajman or Al Quwain, once they reach to a certain level, they will have to go to the federal court, which is located in seat in Abu Dhabi, because it's the capital of the country. The UAE law, the UAE laws are coming out of the civil law, which anyone who has worked in the French system or has worked in the Middle East, most of the laws there are coming from the civil background. That's why the judicial system here, you see that most of the Arabic countries, maybe with the exception of Saudi Arabia, have very similar levels of the court, have very similar processes. We're going to be talking about that. And of course, some of the European countries that still apply the French system, which brought in the civil law, have very similarities to the laws and to the processes that we apply here in the UAE. Some of you might be asking about the Sharia. We all know the UAE, in its constitution, relies on the Sharia. But of course, they apply, like I said, the civil law, and the courts are of civil nature. That is the formation of the judicial system here. And if the constitution of the UAE and the laws of the UAE, they refer when there is no law that can explain a certain matter, and if there is no precedent or jurisprudence to that, they can refer back to Sharia. But since with all of my experience here in the UAE, I've never seen that, because all of the laws of the UAE cover almost every aspect, and that's why we rely back on the civil law. Of course, with the exception of the matters that fall under Sharia, like, for example, the family laws or the inheritance, family status matters, all of those matters will fall under the Sharia law, of course, and it has its own application in that regard. The system of the UAE courts, as I mentioned, is of civil nature, applying civil law. Hence, we have three different levels of the court, starting with the first instance court, then going to the appeal court, and finishing with the cassation court. And I'm sure, again, a lot of you are familiar with that. That's why, like I said at the beginning, we have the local and the federal. Okay. Also, we have the Supreme Federal Court, where some of the matters, specific matters, would be referred to that. So, since they are applying the civil law, and we have the three levels of the court, any case will be starting with the first instance court. Of course, I'm going to be talking how we're going to prepare for that litigation after I explain a little bit about the three levels of the court. We start with the first level of the court. After we receive a judgment, we have, of course, a certain duration and time to appeal it. And after the appeal has been issued, also we can go again to the cassation court. Some exceptions here are made relating to some of the claim amounts. Whereas, for example, in employment cases, if you have a labor dispute or an employee dispute with the company, if that case is below 20,000 dirhams of value, it will have no means to be appealed. And that, of course, is made due to the small amount of the claim, and not to be, like putting a lot of burden on the courts to be again reviewed by a second level of the courts for that small amount. As for general cases, commercial, civil cases, other kind of cases, if the amount is not above 500,000 dirhams, the amount of the dispute, it cannot go to the third level of the court, which is the cassation court.
Let me interrupt you. Several participants prior to the webinar, they sent us some queries as they're not really familiar with the whole litigation process, and they asked whether if someone with a little knowledge in litigation process, could you please provide a simple start to finish summary of this?
Of course.
Of this process?
Just to guide you through all of that, if we take an example of a commercial agreement between a company and another supplier, for example. The supplier supplied some products and he was not paid. What does he do? Firstly, we need to always check the agreement that we have between those two parties. The party who's wishing to litigate or claim for his unpaid products. Of course, I always advise to seek legal advice, go to a lawyer. Don't rely that you know the law and that you have read and you have dealt with so many businesses and you are able to do that. I've seen it a lot, I've heard it a lot, and then they come back to us and say, we did a mistake and please now help us. And sometimes they come at a late stage where the help is not as much as possible if they came from the beginning. Anyways, so any agreement that is drafted between the parties must include a clear clause that talks about dispute resolution, meaning how we resolve if a dispute happened between two parties. A lot of companies, we see it in big contracts here, they have several steps they take among the parties prior to reaching the level where they have no other option but to go to court. So that's why I was mentioning that we need to review the agreement to see if there are any pre-steps that needs to be done before we reach the litigation part or before attending to the court and submitting a case. Now, this is because of two reasons. The first reason, of course, if you are able to settle it, I know lawyers will not like that, but then you don't need to go to court. You'll save yourself time and money. If, of course, the settlement is fair and logical. Second reason is that if there are mandatory steps in that dispute resolution clause mentioned in your agreement, and if you do not follow it, and then you go to court, you might get a dismissal of your case based that you submitted your case too soon. Meaning, if the agreement that we have talks about for example, mediation between the parties or settlement settlement stage between the parties before we go to litigation, then this must happen. If the agreement talks about that a party should be notifying the other party and then he must wait, for example, 30 days for that party to ratify or fix that issue. Also, if you do not do that, that might affect your claim once you go to court. So it's very important for us to know what the agreement talks about. After that, if we skipped all of that, or if we have done all of that, and we reach a point where all of those mediation sessions did not proceed well, then after, of course, we consult a lawyer, we have to go and prepare for the case in front of the court.
One of the queries we received is whether the UAE law is an amicable settlement friendly country.
Yes, the UAE always encourages parties to a dispute to try to mediate among themselves and to try to find a good settlement among them. On top of that, there has been a center established in Dubai, which is called the Settlement for the Center for Disputes Settlement, but they only made that limited to amounts that are not exceeding 200,000 dirhams as the amount of the dispute. Also to ease the burden from off the shoulders of the courts, and not to have the judges and everyone dealing with cases that can be solved easily and sorted out easily. Okay. Also, for example, if I take the example of employment cases, there is a mandatory step where if an employee wants to claim for his employment rights, he must go firstly to the labor office or the labor ministry. He should file a claim there, and that claim will be mediated between the company and the employee. If the labor office failed to mediate among them, then the case will be transferred to the court, to the labor court, of course. As I mentioned, it is a mandatory step, meaning if the employee goes directly to the court without passing in this mediation phase at the labor office, his case will be dismissed due to lack of a formality that he should have done. So to go back to what I was discussing, we skipped through the agreement. We saw if there are any pre-steps that we should be doing, mediation meetings, legal notice maybe to be sent before we go to court. And then we went to court. We hired a lawyer, of course, and we give him all of the documents. Firstly, like any other case or any other country that deals with civil laws, the lawyer cannot present the claimant without a power of attorney. That power of attorney should be notarized at the notary public in UAE to give the authority to that lawyer to represent the claimant and to attend all court hearings and do anything that is in the favor of his client. After that, of course, the lawyer will be gathering the file documents and putting them in his bundle of documents, prepare his claim memo, and submit it to the court. One of the most advanced things that I really appreciate about the UAE court system is that now we have everything is done online. Of course, it has been done even before the COVID hit, but after the COVID pandemic hit, it became a lot and a lot more. And so we have an online system where just by sitting in our offices on our laptops, we as a law firm, we have access to that court system where we can upload the case memo that the lawyer has prepared. We can upload the documents that have been gathered by the lawyer, and it is sent on the court system. One of the amendments of the civil procedural law that tells us how a case is submitted introduced something that we call case management department. The role of the case management department is to review what we just uploaded on the court system, meaning the claim memo and the bundle of documents that I just mentioned. Their role is to organize as formalities the process of the file, also in a manner to reduce time and to reduce the burden of the shoulders of judges. Their job is to gather the needed documents, the needed memos, do the needed notifications to the parties before the file is sent to the judge. So we file this on the court system. It gets reviewed by the case management department, and once they have all of the needed formalities, they approve for the payment of the court fees. They send us a link, and that link also we pay the court fees online using the firm's credit card. And automatically, once the payment has been done to the court fees, a notification to the other party, to your opponent, to the respondent, that a claim has been made against you, and automatically we will receive from the court system the case number. We will receive from the court system the first hearing date, and as well, all of this will be notified to the opponent, to the other party. After that, the case management department start after the payment has been done, after the first hearing is scheduled. That first hearing is not with the judge. The first hearing is still with the case management department. They gather all of the memos, all of the defenses that both parties would like to do. They submit everything, and then at that point, once everything has been submitted, then that file is transferred to the concerned judge. Again, in a manner to reduce time and to reduce the burden. The judge will start looking into the file. He will, of course, conduct hearings. Also, our hearings are being done now, again, online through the court's online system. So the amazing thing about it is that anyone can attend. That even forced some amendments to the laws, where, for example, in criminal cases, the person should be attending himself in front of the judge. Now he's attending online, so the judge must accept his attendance online because he is attending. So we conduct the hearings online. I can also mention here that Sheikh Mohammed bin Rashid, ruler of Dubai, Prime Minister of the UAE, has announced last week that he's pushing and instructing that 80% of litigation hearings continue to be online regardless of the COVID, because they could see how much that has been easing a lot of the processes for everyone. I can also mention here that, for example, if someone cannot travel to the UAE to initiate a power of attorney, as I mentioned at the beginning, he can now do it online, where the notary public will call him on video call to ensure that the power of attorney, just to guide you exactly what we do, we prepare the power of attorney, we apply it also online on the notary public online system. We send it to our client for him to sign it. That attachment we forward it to the notary public. Then the notary public will assign a time where he will call on video call the client, no matter where he is, even if he's in the far end of the world. He will ask him to show either his passport on the camera or his Emirates ID to ensure that this is the person that is signing on that power of attorney. And he tells him, do you confirm that you're assigning this lawyer to do this? And once it's done, we receive the power of attorney stamped by the notary to our email as a firm, and then we take that and we also apply it to the court. So you could see how much this is easing the life of everyone, rather than having to travel to the UAE to go to a notary public to give power of attorney to the lawyer. So this is also done online. So to go back to the case, we attend online hearings with the judge. We submit memos. The judge here will have, of course, his own discretion in, for example, deciding to listen to some witnesses, maybe to decide to appoint a court expert. You know, most of the cases need some technical aspects, for example, financial, engineering, mechanical. So the court will assign an expert. We're going to be talking about more the role of the experts in the coming slides. And that expert will have a certain mission assigned by the court. He will meet with both parties, he will listen to both of them, and he will prepare his report and submit it to the judge. The judge or the court, of course, have full discretion as per the law to take what the expert said or completely ignore it. Because, of course, the expert's opinion is just of a advisory manner. It's not obligatory. But we have seen from our experience that 99% of expert reports are accepted by the judge who appointed them. And the result of the expert report will have, of course, big effect on the result of the case. After that, a judgment will be issued by the court. That will be the first instance judgment. In civil commercial cases, we have a time frame of 30 days to appeal that judgment from the date it was issued. If the parties were attending, meaning what we call here, the judgment was issued in presence of the parties. If it was issued in absentia against one of them, then it is 30 days from the notification of that party when he was notified of the judgment. Again, 30 days, same, almost similar process. We go to the appeal court, we file an appeal online, we register it, gets reviewed by the case management department, pay appeal court fees, notify the other party, and then attend in front of the judge. Again, online hearings until we have a judgment from the appeal court. Once we have a judgment from the appeal court, we still have the right to go to the third and highest and final level of the court, which is arbitration court. And we have 60 days. If you notice, from the first instance to the appeal, we had 30 days. Now from the appeal to the cassation, we have 60 days, which is double the time frame to go to the cassation court. Just to mention here that cassation courts, as we call them, are the courts of law, meaning they can only look into legal matters. They cannot touch the merits of the case, okay, whether the agreement was done properly or not done properly. They consider that as part of the merits, which the Court of Cassation will not look into. They only look into matter of legalities, meaning that the Court of Appeal worked properly on the file. Did they miss any legal step, any legal process? Was there any kind of a request made by one of the parties that the court forget to tackle? Okay, of course, I'm not talking here about a defense that was rejected by the Court of Appeal. I'm talking about a defense or a request that the Court of Appeal completely disregarded or did not look into. Was the witness that they listened to at the court, did they make him swear as per what the law requires that the witness should be swearing in front of the court? So those are the legal matters that the Court of Cassation will look into. That's why it's called the Court of Law. So 60 days to file that appeal in front of the Cassation Court. Of course, you don't have to wait till the 60 days end. You can do it from the next day, but of course, if the file is ready. And again, online system, we file, we pay the court fees. The difference of this court, other than it's the court of law, is that they do not have hearings, meaning the parties will not attend in front of the Court of Cassation unless the Court of Cassation itself says that I need to listen to both parties. But usually they don't see the parties. The person who filed the appeal in front of the cassation will submit his cassation memo. It will be notified to the other party, who has 15 days to respond. And after that, nothing happens except inside the Court of Cassation itself, where the judges convene in their chambers by themselves and they decide on what to do with this cassation. So that's why it's different from how the first instance, where we attend, where we submit memos, documents, witnesses, where an expert has been appointed, an expert has been submitting his report. Court of Appeal, very similar to the first instance. We attend, we submit memos, documents, everything. And also expert report could be appointed as well by the Court of Appeal. Again, we're going to be discussing more about the experts in the coming slide. The Court of Cassation, unlike them, they don't do that. So they decide on the matter among themselves. And once that judgment is issued by the Court of Cassation, that's it. The case is done. If you win, you win. If you lose, you lose. There's nothing you can do about it. One thing I would like to mention, even it's a very detailed matter, is that the Court of Cassation, the Court of Law, they have two decisions that they can take. One is dismissing your cassation appeal, saying there's nothing of a legal matter here, everything was done properly, and your cassation case has been dismissed, meaning whatever judgment has been issued by the Court of Appeal has now been confirmed. That's the first decision they can take. The second decision they can take, if they find there is a legal mistake or a matter that needs to be reviewed properly, what they do is that they send back the file to the Court of Appeal, telling the Court of Appeal, you missed on this point or on this matter, you have done something wrongly, check it, and then the file will go back to the Court of Appeal. The Court of Appeal will have a hearing to the both parties, and tell them this is what the Court of Cassation has said, what is your comment, and then again there will be a judgment issued by the Court of Appeal. So those are in general, how the steps we usually take when it comes to the 3 levels of the court.
I will be interrupting you to raise some questions that we received because the Q&A won't be enough for
Sure,
panelists.
please go ahead.
Okay, so how long does it typically take for a final judgment to be obtained?
Okay, now I know a lot of you would have that question, how much time it will take. Definitely, it all depends on the complexity of the case. We've seen cases finishing in 6 months, we've seen cases finishing in 3 years. So a typical normal case would take between 6 months to a year, passing through the 3 different levels of the court. That's a normal process because we need to take into consideration weekends, holidays, and the process of the court. We need to take into consideration the notification period at the beginning. If you're claiming against someone and you're not able to notify, you have to try to do whatever you can to notify that party, that opponent. And that, of course, will take time. So all of that will be affecting how long or how short the duration will be.
Okay, here's another question. What is the fastest way to recover the overdue from the customer unwilling to pay the service provider via litigation?
Okay. As a law firm, we receive a lot of commercial cases. People who are owed a certain amount of money, companies, suppliers, developers, subcontractors, whatever. The UAE laws have in its law something that's called a payment order. That payment order is a very fast-track process that companies can tackle, can use to try to get their money ASAP through a court order. Now, there are certain conditions to that payment order. Again, we go to a lawyer, we do the power of attorney, everything I mentioned, and the lawyer will submit to the court what we call a payment order. That request is submitted without the knowledge of your opponent. He's not notified until the order is issued by the court. Now, to have that, there are specific, special, strict conditions for it to be considered as a payment order. One, it has to be a commercial debt. Debt between 2 companies is always considered commercial. The amount must be quantified clearly, must be confirmed, 1 million, 2 million, 50,000, 100,000, whatever it is. And there should be an acknowledgement from your opponent that, yes, I owe you that money. So those 3 main things are very important to have. Another formality the payment order requires is that the claimant should have sent, before filing the payment order, a legal notice, a notarized legal notice, meaning legal notice sent by the notary public, not a legal notice sent only by the lawyer. It's not enough. It has to be notarized by the notary public. And because the notary public are a part of the local courts, they have court bailiffs, the people who notify. So that's why the law has mentioned it has to be a notarized legal warning. So I send that notarized legal warning to my opponent as per the law of the payment order. I give him 5 days. If he fails after the 5 days, then I can go to the judge, gather my file again, make a power of attorney, go to the lawyer, submit the bundle of documents, the same process I mentioned before, online registration, everything, and I give it to the judge. The judge in his chamber will review the documents, again, without notifying the other party. Once he sees that everything is there, he will issue a payment order, meaning he will issue a judgment ordering the other party to pay the amount that you are claiming for. Once that order has been issued, it will be notified to the opponent. By law, they have 15 days to appeal it. And here you can see now there is a difference of the time frame from the normal cases that I spoke about before, which was 30 days. Here in the payment order, because it's considered as a special way of legal process, the law specified the appeal of that payment order by 15 days and not 30 days. where the opponent can file an appeal on that payment order in front of the Court of Appeal. And of course, the Court of Appeal will look into the matter, and again, they will issue their judgment either by overruling the payment order if it was something wrong, or if the opponent maybe has paid, or by confirming the payment order, and as such, the opponent will have then to pay, and that order has been confirmed.
Okay.
Another question we have?
How are interim measures granted in the UAE? What kind of measures does the court usually allow?
Okay. Just to note that while I'm discussing, because we have received several questions, so in order to speak about the litigation process and in order to answer as much possible questions that we have received, we are including those questions while I'm speaking. One, to make it more interactive, and second, to be able to answer as much queries as much as we have. So to go back to the question that Rita just asked me, interim measures. The UAE courts, based on the case itself, can undertake different interim measures. Interim measures, as we specify it, are measures that the court can take immediately to ensure, for example, the court can have a travel ban issued against your opponent. I will speak how this is done. The court could have what we call a precautionary attachment on the assets of your opponent. Why it's precautionary? Because it is still while the case is ongoing. So the judge here will issue a precautionary attachment. He will block the assets or the bank accounts. And yes, unlike some of the countries, for example, my home country, Lebanon, you can never have a block on a bank account because we have a law that's called bank secrecy law. So bank accounts cannot be touched. UAE, unlike my country, we can block bank accounts. So I can ask the judge to block a bank account of my opponent. Of course, I need to have sufficient documents and proofs for the judge to see that I have what we call some kind of a confirmed debt for him to either issue a travel ban, so my opponent will not run away from the UAE and then he disappears and I cannot recover my money back, or from him or from my opponent not able to cash out his bank account, and then I go after him and his bank account is empty. So that's why the judge will issue a precautionary attachment. This is only during the course of the case where that bank account is blocked and he cannot touch it, or his asset is also blocked and he cannot sell it, until we have a final judgment, the one that I spoke about before, which is the first instance appeal and cassation court confirming the judgment, and then I can go and enforce my judgment on that bank account or that asset by recovering my debt from him.
What about interim measures on individual, like travel ban?
Okay. Yes. As I mentioned briefly, also travel ban, if I could prove to the judge that there is a risk of my opponent running away, especially here in the UAE, we know that we have over 220 nationalities. We have a lot of expats living in the country. So that expat could just pack his things and go back to his country and leave. And so if I could show the judge that there are a big risk of that individual running away, he could issue a travel ban against him, meaning he cannot travel. He will stay in the country until the case ends. Okay, another point I like to talk about is that in certain cases where, for example, employment and rental disputes cases, the courts here tend to ban the manager of the company that you are claiming against, whose name is on the trade license, from leaving the country until the case ends. So I'm going to elaborate more. If an employee has a case against company X, and he took a final judgment for his gratuity and of service rights, and then he starts enforcing the judgment, and then he finds out that that company has nothing anymore, no bank accounts, no assets, nothing. He can head to the judge, and the judge could order for a travel ban against the manager of the company. The manager, by law, is the one whose name is mentioned on the trade license of the company as the manager. The courts here sees that manager knows where the money of the company is, and accordingly they could ban him from traveling, and it can even reach to a point of detaining him, meaning the manager of the company, even in a case that has a civil nature, employment, rental, he could go to jail, detained in jail until this amount has been paid. And again, we have seen it a lot. We have seen a lot of people being detained at the airport or banned from traveling because they have an employment case against the company they manage or a rental dispute. So also we could see how, you know, strict the system is in trying to recover the amounts of the employees, of the rents, whatever. So also that's something that, and maybe in other jurisdictions, you don't see it much.
Okay, so one last question before we move on to the PowerPoint. What is the procedure of a lawsuit that could be held in the UAE on behalf of an entity non-residing in the UAE?
Okay, this very important question that came, that what if a foreign entity that resides outside of the UAE has a claim in the UAE? Very simple answer. It will be treated as if it's a company that's residing here. The law did not limit the ability of someone to claim or to litigate on the soil of the UAE only to companies that, or individuals that are in the UAE. No. So for example, if we have a company in some European country that have supplied some products to a company in the UAE and they failed to pay them, simply that company that's residing outside of the UAE could engage with a lawyer in the UAE to file a claim against the other companies. So it will be treated in the same manner and in the same way. And we should always remember that the UAE is very much of an investor-friendly environment. So that's why investors or foreign companies are treated in the same way, in the same manner. There is no separation by the laws for locals, non-locals, for foreign companies, local companies. They are all under they are all treated in the same manner under the eyes of the law. So they are all equal. So again, that foreign entity can only needs to hire a lawyer in the UAE who would file a claim against that company and go with the same process that we've mentioned before.
Okay, so now moving on to the PowerPoint. What about experts
Okay.
for UAE courts? Is there any requirement for the experts? Should
Okay.
they be registered?
We've mentioned briefly before during the while speaking about the course of action in the case that the court is entitled to appoint a court expert. Someone who's named as a court expert, one should be registered before the Ministry of Justice. Of course, according to his specifications, whether he's an engineer, a doctor, mechanical, auditor, accountant, whatever his expertise is, he's has to be registered there. And that registration will allow him to be selected by a specific department that is also under the courts of the UAE. Each emirate, for example, Dubai courts, they have a department called experts department. The judge, when he decides on appointing an expert during the course of a legal action, for example, he needs a financial expert. The judge doesn't know who the expert is. He just says, I appoint or I instruct for the appointment of a financial expert whose job is to review the documents, check the audit records, check the statement, bank accounts, whatever. This order of the judge goes to the experts department that is part of the courts. They select from the schedules that they have a financial expert according to the expertise that the judge is looking for. The judge might need a civil engineer or a mechanical engineer or an electrical engineer. So based on the specification that is made by the judge, the experts department at the court, they're the ones who say this file goes to Mr. X or Mr. Y or Mr. Z, and he will be the one appointed. So that's how experts are appointed. Now, experts, once they are appointed or selected to that particular case, as well, the judge in the appointment decision, he will specify expert fees, because of course this expert is not going to be working for free, and the judge will say who will pay the expert fees. Is it the claimant or the respondent? Once the expert gets paid and receives a copy of the file, he will contact both parties. He will conduct several meetings with both of them. He will ask them for certain clarifications, documents, whatever they are saying. And then he has even the right to move to the company's offices, check their computers, check their ledgers, check their bank accounts, to initiate and to prepare a full report that he's going to be submitting to the judge. Why he must be following the steps? Because if he misses out on what the judge has requested from him, it is easily for either parties to the case to challenge that report and say that the expert did a mistake here or there, and that might lead to that the judge might disregard completely that expert, choose another one, or send to the appointed expert, tell him you missed out on this and this, go and amend. That's how expert reports are being done.
Are the costs of experts fair in the
UAE? The cost of the experts are honestly decided by the courts. Recently, the value of the fees of the experts have been modified and have been increased in order in a way that the judge can accommodate the amount of work that the expert has made, and of course assign the proper amount of fees to be paid for the expert. So I can say now, definitely after it has been modified, I could say they are fair.
Okay, so now moving on to the witnesses for UAE.
Okay, you all know that in any case you can rely on witness statements. Those witnesses can be instructed either by the judge himself. He could say, I want to listen to Mr. X or Mr. Y, or the witnesses can be requested to be heard by either party to the case. So if I have a number of witnesses that I need the court to listen to, I send a request to the court with the names and contact details of those witnesses. It's up to the judge to accept or to deny. He could accept all of them to be heard. He could deny all of them. And if he accepts, those witnesses will appear in person in front of the judge. As I mentioned briefly, they have to be taking the oath in front of the judge to say the truth. And as I mentioned, if you remember, one of the points I spoke about in the cassation appeal is that if the witness did not take the oath, that's a legal matter. So anyway, the witness will take the oath in front of the judge and he will give his statements. Now, another way of doing that is that I, as a lawyer, can take witness statement from someone in case he's not able to attend, or for me to know if the judge might not accept to listen to this person. So what I do is I take that witness statement to make it official. I take him to a notary public to have the witness statement notarized in front of the notary public, and then I add it to my bundle of documents as a proof to what I have. So that's, if you want a more better or more easier way to have a witness statement done. Of course, it's always in the discretion of the judge to, again, request that he listens to whoever made that witness statement. Or, as I mentioned, I prepare a request, send it to the court that I have 5-10 witnesses I need the court to listen to. What also is needed to be mentioned here is that witness statements or witnesses, when they are heard by the court, we don't have what we call cross-examination. Meaning I cannot ask directly to the witness a certain question. I have to direct my question to the court. The judge has a full discretion to accept my question or deny it, considering that it's maybe irrelevant, and the judge will be asking the witness my question. So we don't have the principle of cross-examinations. We cannot directly examine the other parties. Always has to be done by the court, by the judge, and not by us.
Okay, so now with regards to the translation.
Okay, the constitution of the UAE clearly says that the language of the courts is Arabic, because we are in an Arabic country. So every document that has to be submitted in my bundle of documents that we submit to the court, I must send it to a legal translation office. A legal translation office is a translator that again is registered with the Ministry of Justice. Also, he takes an oath that he's going to be translating fairly and properly. And we send our bundle of documents that are in English or any other language, and he translates them and he stamps with his official stamp in order for the court to accept a document that's not drafted in Arabic. If it's in Arabic, of course, I can submit it as is. I don't need to have anything to it. But if it's in a different language, I need a stamp of a legal translation on that document showing for example, the English document and its translation into Arabic. Other than that, we will not be able to have the court review a document unless it's in Arabic or translated to Arabic. Okay, one thing again to mention is, and that's part of the developments that the courts are always doing in the UAE, that Abu Dhabi courts, for example, obliged party to a case, for example, if all of his documents are in Arabic, okay, he must translate them to English to allow his opponent, if he doesn't speak Arabic, in order to read what are there. So here we see how fair and how like sophisticated the processes are in the UAE, where a party to a case whose language is not Arabic and who's a party to a case must receive the documents in English if they are originally made in Arabic. The claimant must translate his documents into English or to whatever language his opponent speaks in order for that opponent to read what those documents talk about. So again, a very important development in the UAE, and I really should mention here that we as lawyers, we are like learning every single day new things that are being introduced with the legal system here in the UAE. There are always new developments. One of the developments I can tell you about notifications. I can notify my opponent through WhatsApp. Yes, by using WhatsApp. But of course, I have to take the approval of the judge of the court to say I have no other means of doing that. The judge will allow me to send the notification through WhatsApp to my opponent, take a screenshot and send it back to the judge, and he will consider my opponent as being notified. Not to mention notifying by email, notifying in person, notifying by a court bailiff. So you could see how developed the system here is.
With regards to the court's e-services.
Okay, we spoke about the e-services here of the court, and we could see that also the UAE has introduced the e-signature, meaning documents that have an electronic signature. If they are signed electronically properly, they can be accepted as original documents, and that document can be like considered properly in any kind of litigation. One thing here Rita is going to be discussing very briefly. All of my discussion till now, I was talking about the local courts of the UAE. Okay, the normal litigation process. You all know that UAE consists of several free zones area. We all know that the UAE has two financial centers, the Dubai International Financial Center and the Abu Dhabi Global Market Square. Those two areas have their own laws, have their own courts, have their own system that is completely separate from the legal system or the judicial system of the UAE. So my colleague Rita will be just passing quickly through them. I'm aware of the time here to just take you through, and this is completely different from everything I have mentioned before. Rita, please go ahead.
Okay, so as has been tackled by Haytham, the UAE has established several free zones, around 45. But what interests us here in this webinar are two of them, being the Dubai International Financial Center and the Abu Dhabi Global Market, the DIFC and the ADGM. So these two free zones, they have their own independent judicial system. In a nutshell, they have their own courts. They are referred to as offshore courts as compared to the onshore courts, the UAE courts. They are competent to look into civil and commercial disputes, not criminal disputes. They operate under the English law system, whereas, as explained by Haytham, the UAE courts, they operate under the civil law system. and they have their own rules and regulations. The whole litigation process before the ADGM and the DIFC is different from that of the UAE court. We won't go into the details, as this would take a whole session on its own. But these two are competent to look into disputes when the parties expressly refer to ADGM or the DIFC as a dispute resolution mechanism, or, for example, when one of the parties is a body or company that is licensed in the ADGM or the DIFC, these courts would still be competent to look into these disputes, or when the contract has been in part or in whole executed, or when a certain transaction has been carried in the DIFC or ADGM. Okay, so there's also a strong collaboration between the UAE authorities, the judicial system in the UAE, and the ADGM, the DIFC. They entered into protocols and memorandum of understanding in order to regulate such cooperation and to facilitate the enforcement of awards and to make a distinction between the competence of these two. So this is a brief about the DIFC ADGM. Now moving on to arbitration. We received a lot of questions. What is arbitration? How can someone resort to arbitration, and how is it done? So in brief, arbitration is a dispute resolution mechanism as an alternative to state courts. Parties can resort to arbitration when they include in their contract an arbitration clause in which they agree that any dispute arising out of the contract, the interpretation, execution, or validity of this contract will be resorted to arbitration. The arbitration clause is really important. So we advise the parties to always resort to their lawyer and take their advice with regards to the arbitration clause in order not to have a defective arbitration clause that would annul the award at some point and create jurisdictional issues. So in this specific arbitration clause, the parties could tailor the whole arbitration process. They could agree on the number of arbitrators, on the language of the arbitration, the choice of the law of the procedure, the law of the substance, and the seat of arbitration. One thing to mention about arbitrators is that the arbitrators should be an odd number. Usually it's either a sole arbitrator or a 3-member tribunal. They could also specify the qualities of such arbitrators. So for example, we can say that we want our arbitrator to be an Arabic speaker, or to have a knowledge in construction if it's a construction dispute, and so on. And the agreement of the parties will be binding, and even the tribunal and the institution and the whole procedure would abide by this specific arbitration clause. Now, as to the types of arbitration, we have two types of arbitration. There is an ad hoc arbitration and institutional arbitration. It's institutional when the parties refer to a specific arbitral institution in their arbitration clause. For example, they say, whenever a dispute arises out of this contract, we would like to have the DIFC LCIA rules applied. This is an example of a reference to an institution. Whereas when an arbitration is ad hoc, means that the parties would determine all aspects of the arbitration on their own, without the need of any arbitral institution. Now, specifically in the UAE, we have several arbitral institutions. Some of them are onshore, others are offshore. We can see onshore, we have the Dubai International Arbitration Center, the ATCAC, several others, and offshore, the bigger two are the DIFC LCIA based in the DIFC, and the ADGM based in Abu Dhabi, and recently the ICC, the International Chamber of Commerce, has established an office in the ADGM. So as a quick brief to the whole procedure before arbitral tribunals, it usually starts, just like the litigation, by the claimant submitting a request for arbitration. And then the respondent would submit a request, an answer to the request for arbitration. And what is interesting here is that the parties could tailor the whole arbitration process, the exchange of memos, by virtue of the procedural timetable. It's like a timetable they would agree upon, how many memos we will be submitting, whether we will be including expert reports, whether we will be including witnesses, and the time limits between each memo and when we will be holding the hearing, and so on. For the witnesses, they will be submitting here an arbitration written statements, and same for expert, they will be submitting expert reports in support of the claim of the parties. And both the witness and the expert could be cross-examined during the hearing. Compared to the UAE law, the UAE courts, here the tribunal and the opposing counsel both can cross-examine the witness or the expert during the hearing. And the arbitration would end with an award rendered by the arbitral tribunal, who has the same effect as a judgment rendered by a court. It is binding, it's final and enforceable. We would then, the creditor of the award would then resort to the Court of Appeal and file an application for enforcement. The Court of Appeal would then render an enforcement order, and then we can enforce it before the courts of execution, just like any other judgment in the UAE. So this was a nutshell, because we're running a bit of time.
Just to add to what Rita just said, is that from the beginning we talked about what you need to check in your agreement before you go into litigation, because your agreement might be specifying, as Rita mentioned, that the dispute resolution clause says that in case of a dispute you go to arbitration under one of the centers that you have that you are seeing on the slide here. So you might not be able to go to the local courts that I talk about. You might need to go to one of those arbitration centers. Nevertheless, after you get a judgment from the arbitration center, since this is a special kind of dispute resolution, and since the arbitration centers, they don't have execution and enforcement, there is an agreement signed with the UAE courts, where that arbitration award goes into a simple legal process with the UAE courts, the local courts, to make it accepted by them and to have it enforced, meaning for the judge to be issuing on behalf of the arbitration award attachment or enforcement or whatever the award has been mentioning. So we can see here the big link between the arbitration awards, again, or the arbitration centers that are issuing the awards, and the local courts in the UAE, because the local courts of the UAE have their execution hands, if you want, or enforcement methods and tools, so they will apply that on behalf of the arbitration centers. We're gonna be keeping a few minutes for some Q&As. So I know we're gonna be, we already skipped 12 now. We're gonna wait just a couple of minutes. I know it's been a short hour. I hope we were able to cover some of the main steps and main topics for this, for how litigation in front of the arbitration and the litigation also. We're trying, there is one question that came regarding what measures after COVID, especially for the tourism and the restaurants that have been affected by complete closure. I could answer that quickly by saying that rental dispute committees, or the rental court, if you want, who deals with the dispute of rents, have been very lenient towards restaurants or any entity that works in the tourism field, by allowing them to terminate the agreement and leave without paying any penalties or without being responsible to pay for what might be coming next. Because we all know, you have a rent agreement that has been signed for a year, you're liable to pay for that year. If you terminate, you'll have a penalty to pay if you terminate before that year. So the courts have been lenient by allowing tenants to leave without paying penalties. So one of the answers is that the courts are being very lenient when it comes to that, especially that company or that restaurant must show the court that they really suffered damages. They had zero income, their statement is zero, in order for the court to accept that kind of thing. If it's a different entity that's still working and generating money, of course the court is not going to be accepting. So the key point here is to show damages or loss of profit in order for the court to be accepting that.
Okay, so we received a lot of questions, honestly, that I'm not sure we'll be able to tackle. One of them is whether the concept of good faith play a role before UAE courts.
Sorry?
The concept of good faith.
Okay, definitely the concept of good faith, it's more, if you want, it's more specific in the common law, but definitely any litigant in any case must be appearing in good faith, and because he mustn't be hiding stuff or under his hands, and he must be allowing the court or the court appointed expert full access to whatever documents they have. So if a party appears to be in bad faith and the opponent can prove that, of course, that will have a big effect on that party that he wasn't acting in good faith. Anything else?
Actually, we received a lot of questions. I don't know.
I'm sorry, you know, like we received a lot of questions, and I'm aware that we've already skipped 10 minutes after 12. I hope we can have another session with our partners, the Oath, maybe on different topics or topics of the Q&As that we are having. Thank you so much for joining us today. We really hope that we were able to deliver this webinar in the right aspect, and I wish you all a good day. And again, much thanks to our partners, the Oath, on this webinar. Thank you.
Thank you.
Thank you, Haytham and Rita, for the practical insight on this crucial topic. Our sincere thanks to the firm BSA Ahmed bin Hazim and Associates for leading the discussion. Gemma Bradley at the firm, thank you for your support in organizing the session. We would also like to thank our legal research partner, LexisNexis, for their support. Also, my colleagues at Niche Publishers, especially to Sandhya Divakaran, co-organizer of the session. A recording of this webinar will be available on the Oath magazine's website. Thank you all for joining us this morning. Thank you especially once again to Haytham and Rita. I wish you all good health and have a wonderful week. God bless.